Good afternoon, good evening, everybody. We are just late for 2 or 3 minutes because we always try to start in between 6 and a quarter past 6, so it's only a very small, a tiny delay. Dear ladies and gentlemen, dear friends and supporters of the Käte Hamburger Center for Advanced Studies, Law as Culture, and especially I'm very grateful to see and to know that the speaker of today really is present today. It's wonderful, and also your husband, very welcome at our center again. We would like to announce, and I would like to announce the lecture that you will give today that will deal with questions of technology disruption, digital colonialism and law in Africa. That's the title of your talk, which is part of an ongoing research for a new book you are writing, and if I understand well, you proceeded a little bit during your stay at the center. In addition to introducing the digital area in Africa, you will particularly address central problems associated with this new phenomenon in the context of law as culture. So the topic of our center, the question remains how a digital legal culture might relate to the complex normativities in the field of legal cultures in Africa. At the same time, it raises question of the post-colonial debate with regard to the analysis of law. Has there been a specific perspective developed by the Center in order to relate to this huge debate or to make even proper contributions to this debate? I have three small points about this. Post-colonialism has not a good press in Germany. By the way, you might know, only some days ago, Andreas Kilb tried to disenchant post-colonial thought in the vein of the debate over restitutive justice of looted art and cultural object as a pure ideology. I don't know whether you have read this article, the 3rd of July in the Frankfurter Allgemeine Zeitung. However, we thought it to be worthwhile considering Upendra Bakshi's thoughts about the future of human rights in the following way. For one aspect of the discussion on human rights has concerned us from the start. How can we critically accept a post-colonial critique of the human rights discourse that deplores economic functionalization? This was the argument proposed by Upendra Bakshi, within processes of globalization, as has been prominently been represented by him since the 90s, without placing the spread of human rights under the general suspicion of serving just capital interests. Which role does the derivation of human rights from experiences of suffering play? This was his really very interesting contribution to the debate, as anchored in the Conditio Humana, where suffering with Mitleiden plays a central role. Secondly, intellectually, the problem of how to observe the key concept of our center, that is law, from which kind of cité, à partir de quel système, is a crucial one. How to conceive law, the basic and the most difficult question at the same time. It may lead you to a communalization of law, to see it in the light of community structures, to see it in the context of cultural structures, law as simply being only a cultural phenomenon, to an economization of the law, etc., etc. It has been a great challenge until now in how far post-colonial critiques are right when saying that the concept of law presented in a universalistic fashion is nothing more than an Occidental fashion. This is a great problem, a great reproach towards all Western and Westernized people who think about law from the side and the perspective of post-colonial theorizing. By way of opening the legal phenomenology to a symbolic, ritual and organizational dimension, as we have tried to do it at our center, that goes beyond normativity written in a text, we intended to include other possibilities to formulate the universal fact of regulating the double contingency of expectations by way of some kind of law, without giving a privilege to the Western type of law. So that was at least an intention of the center from the beginning on. Whether we reached it and whether we can practice, this remains rather open. But how can we grasp the universal fact that in the process of globalization, algorithms might take the role of defining the deontic power and powers in society? A topic we will pursue next week with Professor Zimmer. And what kind of role does it play that these technologically produced normativities exhale the breath of Western modernity? In this vein, Professor Arewa has written, I quote, "A digital revolution has swept across many countries in Africa in recent years. The influx of new technologies has been to a significant degree disruptive. The list of such technologies is long, as you certainly will explain to us. The introduction of new technologies draw attention to patterns of lawmaking within Africa. We had several fellows who worked about African legal cultures at the center, from Senegal, from Ghana, and from Nigeria as well. But the question remains rather difficult in between the colonial structures on the one hand, customary law, local customs, international law, layers of different legal cultures that give a mixture of for the space of normativities in pluralities that are not so easy to be grasped and not so easy to be handled in the same time. So we are very pleased that you have taken the task to talk and to work about these topics in the context of law as culture, and please allow me to present some of the elements that constitute your biography, whatever and however it may be possible to trace an intellectual biography so interesting and so complex as yours. You're a holder of the Marie Schusterman Professorship of Transactional and Business Law at the Temple University School of Law in Philadelphia. You worked there only since 1 year, if I understood right. You studied anthropology at Harvard College and the University of California at Berkeley, where you received your doctorate degree in 1900, some years ago at least, with a dissertation. And the title is interesting because it shows that you come from ethnology and not just from a legal theorist or a juristic background who is for some days in his life just interested how indigenous people are doing law. But because the title of this work is really fascinating, it goes about Tarzan. All of us are very interested in this figure, with the nice subtitle, Primus inter primates, Difference and Hierarchy in Popular Culture. So nobody until now has worked about the implicit normative structure in the Tarzan storytelling, but you will certainly be able to tell us what kind of normativity is prevalent in Tarzan. In addition, you hold a master's degree in applied economics from the University of Michigan, degree from Harvard Law School, So this is very impressive as such. And following those experiences, you have been visiting lecturer at the Center for Afro-American and African Studies at the University of Michigan and a teaching fellow at Harvard University. You also served as a Foreign Service officer in the US Department of State in Washington. Seems to be something else, a different career. And in Uruguay. After receiving your GD, you worked as a lawyer at law firms. That means you only have a practical experience. It's too long, this really, a biography, but I have to tell you, otherwise you won't understand where your competences come from. In companies in Silicon Valley and New York. You also served as a chief financial officer and general counsel of a venture capital firm in Boston, another kind of practice. So we become more and more scared about this competence. Prior to becoming a professor of law at Temple University in Philadelphia last year. You worked before as an assistant professor at the Case School of Law in Cleveland, associate professor at Northwestern University, etc., etc. In 2015, you were visiting scholar at Humboldt University, not the first time that you're doing this kind of work that you're doing with us. Furthermore, you have been a consultant for the World Bank Group and as a vice chairman of the Nigeria Copyright Expert Working Group. I have to stop here in order to say, however, this is not all. Because law as culture is insofar a preferred topic of yours because you worked about music and law, music and film. You have done African studies, technology, business, copyright law, and the very last point of this kind is you're a singer. When asking to make your talk as an Italian opera, you refuse to do it because you have not had the chance to continue your training during this stay at the center, but perhaps the realities you will talk about are sufficiently dramatic in themselves that we need no additional opera effect. I would like just to mention some titles of your work. Investment Funds, Inequality and Scarcity of Opportunity, Accounting for Injustice, Work and Singers, Law and the Regulation of New Technologies in Africa, Zombies, Ghosts and Hollywood, Accounting Intangibles and Intellectual Property Strategies. So the titles are even so appealing that I would like to continue. But instead of that, I would like to invite you to start before everybody will be too much bored by my introduction, but it's only true because you have such an interesting CV. So you are responsible for the length of my introduction in the end, but very welcome again at our center, and we are very keen to listen to your talk. Thank you very much for being with us.
First of all, can everyone hear me okay? I want to say it's a pleasure to be here. Thank you for that wonderful introduction. So I'm going to tell you a little bit about a project I'm working on, and I'm going to I get very excited about this, so I'll try to not talk too fast. If I start to talk too fast, just give me the sign, give me some kind of sign that you're no longer comprehensible. So I'll try to keep it slow. So this is part of a book project. The book is called Disrupting Africa. And I'm still working on the subtitle. My current sense of the subtitle is Digital Colonialism and Development. This book is based partly, well, to a significant degree on archival research. So what I've been doing from an archival research perspective is looking at every law that was passed or adopted in Nigeria during the colonial period that I can find. So it's been several years of archival research. And my goal in looking at those laws is I'm really interested in understanding how contemporary lawmaking practices have been shaped. And I'll talk more about this as I work through the presentation. I also have experience working, I'm a big geek, I'll admit it, I love technology, and I have experience working with technology companies and in science and technology issues in the Silicon Valley, New York, Boston, and in Nigeria as well. So this comes out of that experience. So my focus, the key focus in the book, is how we use culture. I'm interested in particular different strands of culture, but I'm particularly interested in how we use technology, and I'm interested in how we use law, and I'm interested in the overlap of that in African context. And a lot of the focus of my work has been on borrowing. If we think about how we use culture, we often use things from the past to shape the future. So I'm very interested in how we borrow and use existing elements of culture and what the implications are of these types of borrowings. So that shapes a lot of this work. And hopefully those themes will come out as I talk about it. So I'm going to talk first of all about topographies of disruption. And this is going to be very short. I tried to cut back my presentation. It's still quite long, so I may not get to the end. So then I want to talk about technology narratives. Then I want to talk about colonialism, law, and institutions. And then I'm going to talk about issues that arise in regulating new technologies. So the first thing I want to talk about is the concept of disruption, which I know is contested. I'm not really dealing with that contestation. Just to say that, at least in the Silicon Valley and a lot of technology centers throughout the world, disruption is seen in a positive way. Right, we want to, I think as this book is titled, Move Fast and Break Things. This is from a Mark Zuckerberg quote where he said, move fast and break things. Unless you're breaking stuff, you aren't moving fast enough. Now that's one way to look at it. Another way to look at it is disruption is not always neutral. And broken things can't always be repaired. So disruption, just for the sake of disruption, even if we can say in aggregate it's beneficial, when you actually look underneath that aggregate picture, it can be very detrimental to people. So if you look at the Silicon Valley, for instance, where we have tremendous amounts of wealth, I think I saw an estimate, there are 50 technology billionaires in the world, and 25 of them live in the Silicon Valley. So there's just extraordinary wealth in the Silicon Valley. At the same time, there's extensive homelessness. I was talking to someone who visited San Francisco, who'd never been there before, and she said that this is someone from Nigeria who lives in London, and she said she was shocked at the amount of people sleeping on the streets. So I don't know, those of you that have been to San Francisco recently, there are people sleeping on the streets. They actually have hired people to clean up human waste because there's so many people that don't have access to bathrooms. In San Diego, there was an outbreak of hepatitis B a year ago. If you visited San Diego a year ago, they were hand washing things in the middle of the sidewalk all over the city because they have had a hepatitis A outbreak because they have so many homeless people and they don't have anywhere to use the bathroom. So that contributed to hepatitis A. So we're seeing, real economic inequality and real divergences in outcomes. So within this tremendous wealth, we're seeing a lot of people who have what I refer to as scarcity of opportunity. You certainly see that in Africa, and increasingly you see that in the United States, especially in places where there's a lot of economic prosperity, which seems sort of paradoxical, but I think it's a reality. So when we think about technology, we have to think about technology in a comprehensive way and think about not only the positive aspects of technology, but some of the potential negative aspects of technology. When we talk about technology, because we have a deeply rooted tendency to think about technology as progress, we often tend to emphasize the positive side. But there's positive and negative. Why? Because technology is embedded in a sociocultural context. You can't really divorce it from those contexts. And it reflects some of the patterns and may actually exacerbate existing negative patterns within societies. So if we look, shifting to Africa, so if we look at Africa, many African countries today, I'm going to try to focus on the fact we often tend to think about, often talk about Africa as a country. If I say Africa, know that I mean African countries, and I know there are many different African countries with many different historical experiences, and it's very hard to talk about Africa as a single thing. That said, sometimes I do, but I know that's not totally correct. So when we see in Africa today, there are digital technologies everywhere. So we see, for instance, when I went to Ghana in December for a meeting, and when I went to the airport in Ghana, and Ghana has a fabulous new airport. It's really, really quite nice. Went to Terminal 3 of the airport. When you step in the airport, the first thing they do is do facial recognition. And they do it twice. They do it to even let you get into immigration. And then they do it again when you need to process your visa. They do facial recognition again, and they do fingerprints. So there's a lot of collection of biometrics in many African countries today. For national ID, not clear. In fact, Nigeria has 4 or 5 different systems where they're collecting duplicative biometrics for different things. Now, they're trying to consolidate it, but that reflects, in my view, probably a lack of planning in terms of how to think about this. Now, the question you may ask, and I also often have conversations with people in Nigeria, and I had a conversation with people that I was visiting in Ghana. So what happens to all of this information that's being collected? And it's a big mystery. No one really knows. Now, this is obviously a big issue everywhere in the world, but it's a particular issue, I think, in many African countries because there's not a lot of transparency generally. And there's certainly a lack of transparency here. Where I get a lot of my information about who's developing the systems is I go to company websites of companies that are doing biometrics. And I look at how they describe what they're doing for different governments in Africa. And I talk about it more in the book. I don't have time to talk about it today. Needless to say, we're seeing mobile phones, Nollywood, which is the Nigerian film industry that came from an arena where there was literally no analog film production in Nigeria. Nigeria went from basically having no film industry to having a fully digital film industry, which was the first in the world to be as digital. And there were a lot of, and I've written about Nollywood, so biometrics, drones, social media, artificial intelligence, automation, digital finance. These are all, like everywhere else in the world, we're seeing these technologies unfold in many African countries and being used in many African countries. It's important to note that social media in particular is enabling new modes of community building and organization. Now, sometimes it can be overstated. A lot of technology people will say technology is going to change Africa. I'm a little skeptical about that. So you count me as a skeptic. I think you can't just say technology will change things because technology is not separate from the broader sociocultural context. So technology can be transformative, but it depends. It can't necessarily be transformative. So in Zimbabwe, one of the things that one scholar sees is that we're seeing the emergence of digital town halls for expressing dissent and debating the goals, merits, and methods of political and social transformation, and more recently, even as spaces for engagement between citizens and the state. That said, Zimbabwe, even though President Mugabe is gone, the new president in Zimbabwe, one of the first things he's done is shut down the internet. So whether we have real change there, it's hard to know. I mean, that time will tell, but we're seeing some interesting carryovers from past policies, even though we may be seeing a transformation. Now, this transformation is rooted in generational change. It's young people and urban people, so we're not seeing it in rural areas. So the rural-urban divide is one of the most interesting issues to think about as we think about the unfolding of digital technology. Not only in Africa, it's also an issue in the United States, but in Africa, there are very large rural populations. Gender, age are all issues where we're seeing potential differences in how technology unfolds. So just to give you a sense of where I'm going, one of the things I look at, everywhere in the world we're dealing with the question of how do we have these new technologies, how do we fit existing laws and regulations for these new technologies? So that's a universal question today. What I'm going to argue is in addition to that, in many African countries, we have a problem or issue of a colonial overhang. And that's an issue that we have to think about when we're thinking about legal reform and legal frameworks. One thing we've seen is very little comprehensive legal reform of business and commercial laws or IP laws, which tend to be the laws that are the focus at least of commercial technology development in many African countries. Unfortunately, one of the most visible responses we're seeing to the digital era in many African countries is internet and social media bans, internet taxes, and internet shutdowns. I'm just going to briefly talk about internet shutdowns. So those of you who follow Ethiopia may have noticed that Ethiopia shut down its internet last month. And it reflects some of the contradictions. Ethiopia is positioning itself as a place where the digital economy can really advance within Africa. At the same time, the government of Ethiopia is authoritarian and it's very willing to shut down the internet. They said it was because they wanted to prevent people from cheating on school tests. At the same time, there appears to be some kind of political unrest in the Amhara region of Ethiopia, which I think has led to the killing of the chief of staff of the army and perhaps the governor of that province. So there's some kind of political unrest as well. One of the things we're seeing, this is from Quartz Africa a couple of weeks ago, the Africa Regional Director of the Internet Society basically says that state-ordered internet shutdowns are on the verge of becoming the new normal. They're widely used by African governments for a lot of different things. So they're used to stifle opposition and critical speech and to consolidate state power. They're increasingly widespread. We have the first internet shutdown just over 10 years ago in Guinea, where the president there, then president, blocked access to the 4 main internet service providers in Guinea. We've had restrictions, since that time we've had restrictions on internet access in 22 African countries. So you can see that for the big population countries, Kenya, Nigeria, South Africa, have not had internet shutdowns yet. But a lot of smaller countries, smaller population countries, we're seeing not just one, but multiple internet shutdowns. So it tends, and what we're seeing is, if we think about 19 total internet shutdowns, 43 social media blackouts, 237 days of delayed internet, shutdowns ranging from a few hours. The Ethiopian shutdown appears to have been about a week. In English-speaking Cameroon, the internet was shut down from June 2017 to January 2018. And this was a response. Cameroon, as you may know, is divided between an English-speaking and French-speaking part. And the English-speaking part of Cameroon wants more autonomy. And the government has responded to it's not a rebellion, it's a protest against central government policy by shutting down the internet for an extended period of time. In the first half of 2019, we've seen shutdowns in at least 6 countries in Africa, including Chad, Congo, Ethiopia, Zimbabwe, Sudan, and Gabon. So we're seeing a lot of internet shutdowns. The thing to note is this is not a good digital economy policy. For one, Ethiopia, that's trying to position itself as being friendly to startups. Startups were screaming when the internet was shut down. They said, we're trying to do business. No one will take us seriously if our internet gets shut down just when the government feels like it. It's also extremely costly. So some of the countries we're talking about are amongst the poorest countries in the world. So the cost estimates in Cameroon of the 2017 to 2018 internet shutdown are that cost roughly $384 million US, which is 1.1% of their GDP for that year. So they're tremendously costly. In Ethiopia, the cost of the disruption per day is estimated to be $3.5 million. Democratic Republic of Congo, 2 million. Uganda, 1.76 million. Smaller countries, it tends to be a smaller cost because the internet is probably less pervasive there. But this is very costly for countries that already, in many instances, are poor. So with that as background, I want to talk about how do we shape a better digital economy response in African countries from a legal perspective, from a legal and policy perspective. So I first of all want to talk about technology narratives. I don't have a lot of time to talk about this, but I want to start by thinking about the moment of independence. Because if we think, part of what I talk about in the book that I'm not going to talk about very much today is that law represents, when we enact laws, we're implicitly making an assumption about a vision of the future, because we're making laws that we expect to be operative in the future. At the same time, because we tend to very much look back to precedent, law at the same time, and we actually have some strange temporalities in law that I'm not going to talk about. So sometimes we'll look back. I know in the British colonies, when they were doing master and servant laws, they went back to some medieval laws, actually. There's a very interesting article that talks about master and servant law in I forget which colony. But when we think about law, it blends decisions about the present that reflect a vision of the future and embed assumptions about the past. Now, at independence, there was an assumption that something really had changed, right? If we look at Kwame Nkrumah's independence address in 1957, Ghana was the first country in sub-Saharan Africa to become independent. He said, "At long last, the battle has ended, and thus Ghana, your beloved country, is free forever. We must change our attitudes, our minds, and we must realize that from now on, we are no more a colonial, but a free and independent people." And he basically says the new Africa is ready to fight his own battles. The new African is ready to fight his own battles and show that, after all, the black man is capable of managing his own affairs. Now, the thing that's striking about this is, looking back, over 50 years later, the kind of vision of the future that was envisaged at independence has not come to pass. One reason is that they didn't really, I argue, is that they didn't really make much changes in the laws, and that's a fundamental problem that I think has shaped post-colonial Africa. It's not only laws, but the laws and policies that were present at independence. If you look at the Nigeria Independence Act, for instance, of 1960, the Nigerian Independence Act of 1960 basically said we're going to accept all prior laws on the books are valid laws in Nigeria. Some of those laws were incredibly problematic from the perspective of everyday people, because British colonialists didn't enact laws that necessarily, they weren't really focused on the everyday people. They were focused on colonial authority and promoting British commercial interests. But so, to the extent those laws carried on after independence, they weren't really necessarily suited to the type of societies that existed in Africa. Societies that were developing, that were largely agricultural at the time, that needed a focus on small and medium enterprises. There was, for many, many years, small and medium enterprises were entirely ignored, essentially, in the legal system. So hopes for independence have been far from realized. There are positive stories to tell, and I think it's important to note that those often aren't told, even though there are positive stories. However, positive outcomes in many respects are overshadowed by poor outcomes by a variety of measures. Today we have what I refer to as different kinds of uplift narratives that are intended to replicate some aspects of independence narratives. They're intended to shape a vision of the future as to what Africa could be. Now, I'm not going to talk about China uplift narratives, but a lot of them are connected to China. We could have an entire conversation where we just talked about China. So in Q&A, if you have questions, I can tell you more about that. There's also the Africa rising uplift narratives, which you tended to see at the beginning of the millennium, where people were saying, look, all these African countries are growing so fast, the future is only bright. Commodity prices were part of that. They weren't the only part of it. Now that commodity prices aren't so rapidly increasing, some of the Africa rising narratives have gone away. Or is not as prominent. What I think is most relevant to this talk is what I call technology uplift narratives. Now, technology uplift narratives basically assume that technology gives African countries another chance, right? If we can incorporate ourselves in the digital economy, it gives us a chance for Africa, a chance to blend into a world of economic opportunities and social well-being. And technology can then become an instrument through which the growing marginalization of Africa can be tackled. Now, that may well be that's one future path. That future path is not going to happen on its own. I think it's only going to happen if certain past patterns are disrupted. It's not just the disruptive technologies that need to be present. We also need disruption of existing laws and institutions to some extent. To the extent we can. Now, disruption itself can be a source of instability. So I think there has to be careful thought from a policy perspective about how to make that happen. So we see continuing problems in many African countries today that contribute to migration, right? And that's not just migration to places like Europe. There's a lot of internal migration within Africa. If you go to South Africa, for instance, there's a lot of discussion. There are a lot of migrants from all over Africa in South Africa because South Africa is perceived as a place where there's more opportunity. So we see persistent poverty and pervasive inequality, lack of economic opportunities, political instability, persistent authoritarianism, pervasive food transparency, a lack of transparency and access to information, which it really shapes how people in Nigeria, for instance, there's a viral rumor culture that's emerged where people just, crazy rumors exist. So the current president of Nigeria that was just reelected, he was sick in 2017, or it might have been 2018. Don't quote me on the year. He was sick for a long time, and he spent 5 months in London. No one knows why. No one knows what was wrong with him. He just knows it was pretty serious, obviously, if he had to spend 5 months in treatment. And in 2018, he started to look a lot better. So while he was in London, there were all these viral rumors that he had died. Now, a prior president, two presidents before him, had died in Saudi Arabia, undergoing medical treatment, again, for an undisclosed ailment. We don't know what was wrong with him. We know he died. We know that after he died, there were actually proclamations supposedly issued by him, but he was already dead, so they couldn't have been by him. So there were all these rumors that President Buhari, who's the current president of Nigeria, had died. He came back to Nigeria in 2018, started to look healthy, and all of a sudden there are now rumors that he's been replaced by a body double. From, I think, the Sudan. And part of this, these kinds of rumors flourish because there's not a lot of transparency and there's a lack of access to accurate information. In Zimbabwe, for instance, people tracked President Mugabe's health by looking at where his plane was. They could track his plane because they knew what number his plane was, and they would track it and see where he was, and then they would know, is he sick, is he undergoing medical treatment, what's he doing? There's not a lot of transparency, and this is something that goes back to colonialism that's continued in the post-colonial era. Last but not least, demographics. When I look at the demographics, I get very scared because the population of many African countries many African countries are in the midst of a baby boom. So the population of many countries will double by 2050 and perhaps triple by the end of the century. So that means if we think we have problems now, if the current situation continues and that there's a lack of opportunities, persistent poverty and inequality and political instability, things will get much worse when you have 2 or 3 times as many people, 2 or 3 times as many young people. One of my arguments I make in the book is that there are many reasons to change this. The coming demographic doom, what will be demographic doom if things don't change, is a pressing reason, I think, to change. So what are the limitations of existing policies? There are many. In my book, I talk about institutional shortcomings and limitations. There's basically a lack of hybrid policy solutions to address persistent problems evident prior to the digital era. they're problematic borrowing patterns, and I think there's a tendency, going back to the technology uplift narratives, there's a tendency to think digital era technologies will solve problems, right? Which is really it's sort of an understandable tendency. However, we need to be careful in doing that. If we look at automation and employment, for instance, there's an assumption, there's an employment problem in many African countries, significant underemployment, and very high levels of unemployment rates, especially among youth. We're talking about rates that could be in the 30 to 50% range in some African countries. So there's a lot of people that aren't employed. And at least some of the economic studies I've seen suggest that it's basically a problem of lack of demand. The society, within many of these economies, they're not just generating jobs for various reasons. That's a different talk. But I think the Tony Blair Institute last week issued an interesting report where they looked at automation. Automation is happening everywhere in the world at this point, and it's having a big impact on employment, certainly in the United States, where a lot of people that might have had jobs 20 or 30 years ago don't have jobs anymore. This is happening, likely to happen in Africa as well. So if we think about the digital economy in Africa, one of the things that the Tony Blair Institute suggests, which is that automation in manufacturing presents a threat to labor, and threatens African countries' ability to emulate the development pathway of earlier industrializers. So that means even if we had a tendency to have a policy of just doing verbatim copying, it may not work anymore because things have really changed and automation has changed things. So this poses a challenge to development, but it will also offer opportunities. But it requires policies that are flexible and nimble. It's going to likely require a different path for countries that are seeking to sort of get greater economic prosperity today. And I think this is the case with many other technologies, and I think countries that are trying to think about technology policy and legal policy need to really think about this more seriously. So with that background, I want to talk about two things: colonialism, law, and institutions, and I want to talk about some factors that have shaped, that I talk about in the book. So basically, borrowing and cultural mixture, we know. I write a lot about music. Borrowing and cultural mixture are pervasive aspects of human society, right? So we see borrowing and cultural mixture in language, in music, religion, art, folklore, agricultural practices and crops, technology and law. What my research does is focus more on how does borrowing happen, particularly in law, but in other contexts. A lot of my research, this is just examples of borrowing that come out of my recent research. So we can look at the adoption of colonizing country legal systems and laws in colonial possessions, the spread of Italian opera, the spread of Indo-Arabic numerals and double-entry bookkeeping in Renaissance Italy, the global spread of African-American music, which to a significant degree before the recording era spread with people. So you had the movement of former slaves outside of places where they were enslaved. You had the Great Migration in the 20th century, where you had a lot of African Americans moving to northern cities. So you could see music coming directly up from the Mississippi Delta, straight up into Chicago via train lines, where people were going to get jobs in northern factories. A more recent one would be the spread of MP3 audio compression technology, which was actually developed here in Germany, but widely used all over the world today. So if we think about legal borrowing more specifically, there's a lot of scholarship on legal transplants. What I would argue is we need greater attention to context, particularly questions of power, because borrowings in the African colonial context were involuntary borrowings, 100% involuntary. Borrowings today may be a mix, right? Because borrowings today may come from external sources. They may not, from a power perspective, they may not be entirely voluntary. The question is, how do we think about power in the context of legal borrowing? And we also have to think about legal interpretations of laws, treaties, and contracts. Because I think legal power can sometimes shape how we interpret rights. And I'm actually shortly going to talk about actually looted art. I'm going to talk about the Benin bronzes, which I know have been a big debate here in Germany. So we'll talk about how because many people argue, well, the Benin bronzes, Nigeria has no claim because international law should let Britain take the Benin bronzes. I don't think that's quite plausible given what actually happened on the ground in terms of the looting and taking, but we'll talk more about that. We also have to look at lawmaking processes, and we have to look at how borrowings are actually undertaken. So, and again, my basic thesis is that we need to disrupt existing patterns of borrowing in African countries that echo approaches taken during colonialism. because that, in a sense, is reinscribing colonial power relationships and colonial processes in the contemporary context, to the extent we can. Now, if we think about legal borrowing in many African colonial contexts and post-colonial contexts, in terms of sources, they're often single-source borrowing. So if I'm a British colony, I look to English law. If I'm a French colony, I look to French law, even today, and I may not actually look more broadly. Nigeria adopted a privacy law, finally, in January 2019. It's based on the GDPR, which is obviously a world-leading privacy law. It's not clear that it's really customized for the Nigerian context. So it seems to have been close copying of the GDPR, and because of it was a regulation, not actually a law. Because of the regulatory process, there were some problems in the regulation, and some commentators don't even think it's valid, but that's a more detailed conversation. So we often have single-source borrowings, often determined by external powers, external legal instruments, and external donors and experts. And there are real questions of accountability sometimes, particularly with experts. In the Nigerian case, it was a regional imperative. ECOWAS, the Economic Community of West African States, has a mandate for countries that are ECOWAS members to adopt a privacy law. There's also a question of the impact of pervasive authoritarianism on lawmaking and regulatory processes. There doesn't tend to be an open comment period in many African countries. There's not an opportunity to consult with groups affected. When I was serving on the copyright expert working group, one of the things that was notable, we had meetings. We were working on a copyright reform project in Nigeria. We had meetings with all of the affected industry groups, and all of them told us no one has ever met with us to ask us how law could help you or how law might be relevant to what you might need. So there's not a process of consultation, and there's often non-transparent and non-existent or even non-existent legal and regulatory processes, and that goes directly back to colonialism. The colonial state was not transparent for obvious reasons, and it was also very unwilling to accept criticism. And that's something you see that's very common. For instance, one of the legal responses to the digital era I didn't talk about was laws to ban certain types of speech. So Nigeria in 2015 introduced something called a social media law that specifically named places like WhatsApp and WhatsApp and perhaps Facebook. And they basically imposed criminal penalties and high fines for certain types of speech via WhatsApp. And this reflects a very sensitivity to criticism that's very common in African states. It's understandable, but in some ways problematic. And there's often insufficient consideration of local context and local needs in legal borrowing processes, even today. Now in Nigeria, one of the things in the introduction we talked about, there are a lot of different legal frameworks floating around. So I want to briefly talk about, I'm going to focus on customary law and English law, but I want to acknowledge there are other kinds of legal frameworks. So international law is very relevant. There's also Islamic law in Nigeria. So in African countries that have large Islamic populations, Islamic law tends to be a source of law. And there's one of the things that's very clear is there was a lack of robust conflict of law doctrine. So it's really interesting to read colonial discussions about, well, how would this work in different contexts? It's really clear that no one really thought this out very carefully in terms of how it would work. And the reason that they didn't have to is they had power. So they could colonial authorities were ad hoc. They could make ad hoc decisions. They acknowledged, one of the things you see in the colonial records, they acknowledged, one of the things they did, I'm going to show you a treaty, when the Royal Niger Company, which had oversight over a small part of what's now Nigeria, when they first got their charter, they went around having people sign form contracts, essentially, where they just filled in the blank. And then there was form contracts signed by people who were not literate because they marked the contract with X's. So they couldn't read the contract. It's not clear they really understood it. Later, in the colonial records, they basically say these contracts are close to unusual because no one really knew what was going on. So the treaties aren't really usable. Nonetheless, they came up with a solution because it was very ad hoc. So one of the things people often will say is that there's no rule of law in Africa, right? Or that problems with rule of law in many African countries. Those really go back to colonialism, because if you look at the operation of the colonial state, it was very ad hoc. And because they had power, and they did not really have any criticism or critical discussion about what they were doing. They just did whatever they wanted. Now that's caused a lot of problems because some of the laws that they passed or laws that they enacted and regulations that they enacted don't really work. But again, if you have the kind of power that they had, it may not matter if they work. In an independent society, it matters a lot more. So some of these lawmaking processes are problematic in that you end up in a place where things don't really work, and it's not. And in Nigeria, people will often say there's law in the books and law in practice, and that's true everywhere. But the divergence, I think, is greater in Nigeria than in many places, mostly because what's on the books may not be so connected to the reality of how people do things. So one solution to thinking about how do you move forward in terms of lawmaking is to think about what kind of informal practices exist and think about how do you incorporate those informal practices into this existing legal system, even incrementally, in ways that can empower local people and that can advantage the society more generally. So if we think about laws, so Islamic law reached Nigeria from various places. I'm not going to really talk about Islamic law. It was mostly applied in northern Nigeria. In areas with significant Muslim populations. However, during colonialism, Islamic criminal law was largely abolished. We also had international law, which was used to justify things. International law was the basis of the colonial property claims that were made by European powers, particularly at the end of the 19th century. It was also used to justify specific acts, such as the sacking of Benin. There were a lot of contradictions. One of the things we see, there are contradictions on both sides. On the colonial side, there's contradictions in that the Berlin Act and the conception of dividing up African states was based on a stated humanitarian goal of suppressing the slave trade. However, it was put together with a worldview that accepts without question the subjugation of subject or native populations in Africa and practices such as forced labor. It's very clear that the colonial officials in the records I reviewed have no problem with forced labor. They say we're very anti-slavery, but they have no problem with forced labor. By the same token, on the sort of local side, at independence, we see a lot of criticism, justifiable criticism of colonial powers, but a lot of Anglophilia. So there's a lot of acceptance, especially of customs and traditions that come out of that same sort of thing that you're saying oppresses you. So I think it's part of being human is to have contradictions, but some of the contradictions are stark and not necessarily, I don't think these are reconcilable. So customary law is of interest because of course anthropologists have always talked about customary law. So this was typically the zone that applied to local people, who the people the colonial administrators referred to as natives. And it was seen, importantly, it was seen by colonial authorities as a repository of unchanging traditional law, right? It was a repository of something that didn't change. And it's really interesting, there's a standard recital in all the petitions. A lot of local people would make petitions. And there was at least one English barrister in Nigeria who would make petitions, and the colonial office hated them. In the notes, they talk about how troublesome these people are that are making legal petitions, which is fully consistent with the legal system they set up. But they didn't like the fact that these people were making petitions and essentially criticizing them or questioning their decisions. Every petition that talks about customary law says that from time immemorial. And that's sort of underscoring this idea that customary law is something that was unchanging. It's always been there. Now, we know from the work of legal anthropologists and Martin Channick and others that customary law was actually in many respects a response to colonialism itself. However, the views of customary law were very much influenced by anthropologists. And they saw customary law as a body of habits, conventions, or moral standards that was not fit for legal analysis. Rather, it was consigned to the study of anthropologists. So you have this really clear bifurcation between the anthropological realm and the legal realm. And Martin Channick suggests that it's pretty clear that the people doing law in colonial settings didn't necessarily understand English law very well either. I mean, I think they had a very formal conception of law that wasn't necessarily inaccurate, which was consistent with ideas of law at the time, but wasn't actually consistent with law in practice. And so you see things like the School of Oriental and Advanced Studies had a restatement of customary law project. So at one point, they were looking for an expert. They needed a legal expert to talk to them about customary law. So they don't go out and find a lawyer. They go out and find Radcliffe Brown, right? Because he's the expert on law, on African law. And I'm not really sure how much he really knew about law in the way that we think about it, but he did legal anthropology. But it means that we have this fundamental bifurcation in law in the colonial context that I think has not really ever been reconciled in many ways. So European colonial power conceptions of customary law were, of course, evolutionary, as much was, turn of the century, early 20th century. A sense that it reflected a mindless conformity to tradition, and some anthropologists' views, no one dreams of breaking the social. Custom is king, nay tyrant in primitive societies. There's a conception of the primitive mind, spontaneous, traditional, personal, commonly known, corporate, relatively unchanging, and that primitive society was irrational, emotional, incapable of objectivity or individual thought. And this reflects the mindset that colonial authorities also had about locals in many colonial settings. So English law, in contrast, was applied to Europeans it should say British colonies, and perhaps to educated locals. There's some debate about that. Sometimes there was a conception that it should apply to educated locals as well. The vast majority of the population know you have customary law. English people, and they seem perplexed about people they refer to as Syrians, who were, I guess today would be Lebanese. They didn't really know how they should categorize them, so they would sometimes have discussions, well, they're not European, but it just reflects that, in part, this legal system was hierarchical, and it was connected to ethnicity or race to a significant degree. There's not 100% mapping, but to a significant degree. So in contrast to customary law, English and European law was rational and impartial, and it was, more importantly, used as a basis for business and commercial law. And this has fundamental implications for local engagement in business and development that continue to today, because there was no conception of empowering local people to engage in the kinds of business and commercial law activities that might have been undertaken. And in some colonies like Zambia, there was actually formal exclusion of Africans from certain types of businesses and certain locations for doing business. So there was a fundamental bifurcation in law that reflected a bifurcation in society. And again, English law was viewed as the apex of a natural evolutionary process. And if you had a conflict, it was resolved by hierarchy. So English law, so we had ideas like repugnancy, right? English law took precedence over customary law in many circumstances. And however, borrowings from English law don't take account of the implications of the cultural context of the source location. So that means when you translate it, the translation may be problematic or inexact or not really work. But again, they weren't really focused on outcomes, and they weren't so worried about local people, because I think they had a different vision, a vision that I'll talk about in a second more. So if we look at the amalgamation of Nigeria, so Nigeria was actually an amalgamation of multiple British possessions that were at one time administered separately, and they had separate lawmaking. So the Royal Niger Company had its own lawmaking process. They went in, had people sign these treaties. The Crown Colony of Lagos had its own lawmaking process. They were directly overseen by the Crown. There were other protectorates. So in 1901, this is what Nigeria looked like. You had northern Nigeria and 4 or 5 different protectorates in the southern part of Nigeria. By 1906 to 1914 is the formal amalgamation of Nigeria into a country. It was created essentially by Lord Lugard, and his wife named it. You had the northern Nigeria and colony protectorate of southern Nigeria that were merged into the country of Nigeria. And that's how many boundaries in Africa were decided. There were ongoing debates with the French about the border with Benin, and some ongoing debates about the border with Cameroon, which at that time was German. So you have a lot of different elements coming into the country that we call Nigeria today. This happened very quickly. It happened in a very authoritarian, top-down, imposed way, which has implications for continuing implications today. So the British in Nigeria used the treaties eventually to in the first decade of the 20th century, they implemented a system of indirect rule in their colonies. And Nigeria was the first place. It was first used in Nigeria. They selected native rulers with the goal of having the rulers be accountable to the British rather than those over whom they ostensibly rule. And as anthropologist Brian Larkin notes in his discussion of northern Nigeria, indirect rule, at least in northern Nigeria, actually tended to strengthen and solidify the power of traditional rulers. They said we're just picking the traditional people that would rule anyway, but they actually probably gave them more power and removed existing societal checks and balances on their power. So they made them enormously powerful. And these people were still in power for the most part at independence. It also created, I'll talk about later, but it also created a class of elites whose loyalty to Britain was a defining characteristic rather than agency or oversight of local populations. And I think that's a source of continuing problems when we think about behaviors of elites in Africa today. So the British, so if we look at the constituent parts of Nigeria, the British governance systems in Africa were initially based on treaties of protection, similar to the kinds entered into by the Royal Niger Company. So these treaties became the basis for the colonial property claims that we see, and they were actually formed contracts, as I mentioned, that were signed by people who weren't literate, who likely didn't really understand the contracts. I'm going to show you an example of a contract of one of these contracts in a minute. Later, colonial administrators recognized that these don't really work. They said, I think there can be little doubt, but that when the original treaties were signed, there was little understanding of the true situation. That didn't stop them from proceeding nonetheless, but people didn't really understand what was going on the ground or who was actually in charge. So this is an 1884 treaty between the kings and chiefs of Apobo, and you can see it's a fill-in-the-blank form. So all they do is put the name on the first page in 4 different places. They actually cross out one article, and this is the article that basically says there'll be free trade within the colony, within the territory, and that the kings and chiefs will have the right to have open trade with people from all different countries. So they cut that part out. And we can see from the signature line that most of the signature lines are X's. So most of these people were not literate. And the estimate that I've seen is at this time, literacy rates in Nigeria were under 10%. So the only people probably at this time that would have been literate, this time, this might even be a little early, might have been people who had access to mission education. Otherwise you would have, so here, and Apobo is interesting because one of the signatories of this is someone named Jaja, who actually tried to, it shows us some of the commercial impact of colonialism. He actually tried to reach markets. This was during the era of legitimate trade in palm oil. He tried to reach European markets directly himself. He was soon dispossessed of his leadership because I think, in part because the British didn't think that he was compliant enough. So if we think about colonialism and conceptions of law, this is the last section before I then talk about how do we think about legal reform. So I think the idea of external determination that things were externally determined has a big impact on the types of networks that were formed. So one of the things we're seeing today, for instance, May 30th, the Africa Free Trade Agreement went into force. However, which I think is a positive step by any measure. However, if you look at the internal networks, infrastructure networks within Africa, it's hard to do free trade if you have no internal connectivity. One of the things, if you look at the network, that if we want to draw networks between most African countries, they go directly to the colonial power. There's not much interconnectivity within countries, and that has huge implications for local economic empowerment and trade, side-by-side trade of countries with each other. Because you can't trade with your neighbors if you can't fly there or drive there or take a train there. So one of the things we see is that, so if we think about external determination and networks, we have largely external determinations, and we also have enormously powerful elites. So the behavior and power of colonial administrators was used as a model for colonial and post-colonial elites. In fact, someone from one country told me that in his country, they call them the black colonialists, because they're people that basically took power after this was a British colony, after the British left, and they act a lot like the British in many respects in terms of their exercise of power. Now, this is not universally true. There's some very, very people who definitely want to change things, but I think there's a tendency to replicate the past if you don't intentionally disrupt it. So you had powerful local elites and independence, and you had external orientation of varied networks. So I'm going to talk about air networks, and I'm going to show you a picture of air networks. I'm not sure if you've tried to travel internally within Africa before. So let's say I'm in Nigeria, and I want to try to go to a country other than Kenya or Ethiopia. or South Africa. Those are the three countries that have airlines that have internal networks in Africa. It can be very, very difficult. Nigeria doesn't have a national airline. There's some links to some countries, but it can be very difficult to travel internally within Africa. So Africa has 12% of the world's population, but 1% of the world's air travel market. It's expensive and logistically difficult to fly within Africa. And because of their protectionist legal and regulatory hurdles, inadequate infrastructure, high taxes, nationalism and lack of competition, and difficulties in getting permission to start new routes. So this is a global, this is from the International Civil Aviation Authority. This is a global map of airline links. And if you notice, you can't even see the different lines in the United States and Europe because there's so much networked interconnectivity in those countries. If you actually look at the African networks more closely, they're almost all virtually to a former colonial power. If I'm in London, it's very hard to fly to a French-speaking country. I have to go to Paris to fly to a French-speaking country, which tells you that even more than half a century after colonialism, we still have those powerful networks that shaped the relationships between colonial powers and the colonized. The other thing that's more interesting is that we know that air traffic connectivity can lead to great economic benefits in that it can link you to global supply chains. It can also link you to intra-African supply chains. If you want to do just-in-time manufacturing, you can raise productivity. If you want to have tourism, it can enable tourism. So that's why this dispute, I don't know, in late 2018, Burundi decided to reject. There was a planned flight between Nairobi and Bujumbura. The government of Burundi rejected. It was from Jambo Jet, which is Kenya Airways' low-cost partner, and they rejected the route because the plane did not have business class. When I think about emulating colonial elites, this is Exhibit A for that, right? They said that they were unhappy with the planned deployment of a small plane on the route, and it was a small plane because it's a small market. And the small plane was unbefitting the status of government officials traveling to Nairobi for connecting flights to other parts of the world. The government officials require business class seats. This is not the attitude of everyone, but it's not an uncommon attitude. So how elites conceptualize their societies and relate to people within their societies is a continuing issue to think about how to disrupt. So if we think about networks in Africa, it's not just airline networks. If we look at railroads, air, broadband, road, we have incompatible infrastructures in rail gauges, direct connections to former colonial rulers, little internal connectivity between or within countries. This may be changing. ECOWAS, the basis of the Nigeria privacy regulation based on the GDPR, is an ECOWAS imperative. And we have the Africa Free Trade Agreement, which has just come into force. So maybe those could be factors, but it's going to require careful planning because you don't have the infrastructure to support at least a lot of intra-African trade. Now that can change, but it was going to require investments and thoughts. And this is rail gauges. And this illustrates two things. It illustrates the external orientation of networks in many African countries because you see it's direct mine or field to port infrastructure, and it's also all incompatible because it's different gauges. So you don't have you have to really carefully think about plan. Now, Southern Africa is an exception because I think that's one part of Africa where you actually do have a lot more integration and you have a lot more internal connectivity within Southern Africa. Outside of Southern Africa, you can see the same very little connectivity even between countries right next to each other. So a couple of other things, and I'm going to go quickly through this. There's authoritarianism. The colonial state was authoritarian. Many African states today are still authoritarian. So the thing, and it carried over after independence, so sedition laws enacted by colonial authorities were then used to suppress political opponents after independence, which is ironic. You have a lack of accountability and lack of transparency, and that's continued. You have extractive and exclusionary takings, because I want to talk about the Benin bronzes before I end. So you have an extractive approach, right? Colonialism was clearly about the extraction of resources. The idea was we extract your resources and you buy manufactured goods from us. So that's sort of a commonly understood part of the colonial endeavor. So in addition to extraction of natural resources, they were taking of artistic works and cultural material, which I think is worth noting. There's also in all of this what I refer to as objection and dehumanization. So if you look at how Africa was divided into zones, it was like a Monopoly game. It was like moving pieces on a board. There wasn't much thought to the human beings underneath or in those areas. And that reverberates even today. There are bad outcomes from the way the game was played in many respects. And that we also have displays of cultural materials and even natives themselves well into the 20th century. So extraction, I think I talked about, so I'm not going to talk about this very much. And one thing to note is Africans were typically excluded from the benefits of exploitation of these natural resources. That was sort of part of the colonial project. So these are the Benin bronzes. They're pretty well known globally. The reason they're well known globally is that in 1897, the Oba of Berlin, there was an ambush and killing of a British delegation to Benin, which is in southwestern Nigeria. So Britain then conducted a punitive military expedition. They looted and ransacked Benin, setting the buildings on fire and killing many people. They seized thousands of works of art, including the famed Benin bronzes. In 1898, they then sold those Benin bronzes on the global art market. They're considered one of the most preeminent examples of African art in the world. The Benin bronzes, to the extent they come on the market today, sell for millions of dollars. This ended Benin's existence. The expedition ended Benin's existence as an independent kingdom, and the Oba of Benin was deposed, shackled, and exiled, and he died in 1914 in exile. Now, the cultural heritage was seized by British authorities and individual soldiers. There's still families of individual soldiers who own who possess the Benin bronzes today and sell them in auctions, and they're quite valuable. Few artifacts. I'm aware of one family that's returned one of the bronzes that a family member took. The vast majority of the bronzes are in some of the world's most important museums, including the British Museum and the Metropolitan Museum of Art. So the takings of cultural heritage, such as the Benin bronzes, reflected the reality of power relationships and of flexible colonial approaches to rule of law and legal justifications for colonial actions. It's become part of a broader debate today about repatriation of looted and stolen cultural heritage. And President Macron, as we know, has pledged restitution of African art. One of the things that's notable about the Benin bronzes is that they're often displayed with incomplete descriptions of their origins. So it's not really, they're just displayed as if it's a piece of art that someone bought somewhere without an understanding of where they actually came from. I believe the Humboldt Forum has, I understand, 580 bronzes, and there's ongoing discussion and controversy about German return of cultural assets appropriated during colonialism. One of the things that's really ironic is during the era of indirect rule, this was in 1897 before indirect rule, during the era of indirect rule, the British wanted to, they tried to get some of the stools back, the stools of the Oba of Benin. They had an Oba of Benin that was acceptable to them, and they wanted to have a representation of his source of authority. So they tried to actually get the stools back that they sold on the art market 15 years before, and they actually went around to different museums to try to say, would you sell us back some of the bronzes? And I think they ended up, it was a museum in Berlin wouldn't sell them, but they took a cast of them, and then they took them back to Benin so that they would have the appropriate sources of authority. And in a way, I just find that very ironic, that they take them and sell them, but 15 years later, they're trying to get them back to reflect the authority of the indirect rule lawyer. We also have displays of natives in museums and world fairs. So the Hottentot Venus is one of the most famous ones, who was examined by natural scientists by Georges Cuvier and displayed for 15 months by an animal trainer. Ota Benga in the United States was exhibited in the Bronx Zoo with in a monkey house. So we had them treated as objects of art. There were displays of natives at world fairs and in various kinds of cultural expositions in Britain in the late 19th and early 20th century. So I think this reflects the kind of objectification that it was the basis for how colonialism was enacted. So I talked about elite formation, so I'm not going to talk about that more. I have some slides here. One quote, this is from Darwin Asimoglu and James Robinson. Egypt is poor precisely because it has been ruled by a narrow elite that have organized society for their own benefit at the expense of the vast mass of people. This is not an uncommon thing in many African countries. Two things. The British tended to think of their choosing local leaders. They wanted loyalty to Britain, promotion of British interests, and care of the population probably came as a distant third. And they actually pretty much say this pretty clearly. This is a discussion they have about the Emir of Käte, who was visiting London at the time to have cataract surgery, and they basically say he was appointed for his courageous loyalty. And they note that he has British officers residing in the emirate to supervise and guide him. But of course, he's in charge. Probably not. Before I talk about legal reform and end my comments, because I think I'm at time, if we look at the colonial endeavor, it really reflects a portfolio mindset. And I take the conception of portfolio from modern portfolio theory, that's part of modern finance theory, which is really about how investors manage portfolios and make investment decisions, and how they may diversify as part of those investment decisions. If we look at how the British thought about their holdings, this is something that has continuing implications today. They thought about their holdings as a portfolio. So their decision-making in varied elements prioritized British interests and British return on investment in a way, so to speak. So they have to, in a sense, they looked at their colonies as a way to diversify their investments. So that in terms of making decisions about which crops to grow in which countries. So one country might be groundnuts, another country might be cocoa, another country might be gold. If I'm an individual person in a single country thinking about what do I want to do in the future, I'm not going to become cocoa in all probability. I'm probably going to take I'm not just going to develop a cash crop, I'm going to probably take a much broader approach to what kind of crops I'm going to grow. That didn't happen to a significant degree in these colonies. So they made decisions about which resources to prioritize and extract and prices to be paid based on their own interest, and they were happy to sort of assign certain places to certain roles. And that, I think, is a fundamental, from an infrastructure perspective, that's a fundamental thing to think about, and why we end up with colonies that are so rooted in one or two things, and rooted in the production of something that's a raw material that's then used in Britain to perhaps be manufactured into something that's then sold back to them. I think Walter Rodney talked about that, but I think the portfolio part helps explain the allocation of different projects and products to particular regions. So the colonial office officials sought to cultivate this overall portfolio decision. Decisions involving infrastructure were also connected to this portfolio mindset, and legal and policy decisions undertaken with a portfolio mindset are likely to diverge from those undertaken on a country-by-country basis. This portfolio mindset is also one reason they wanted the laws to be the same, because it's much easier to manage if you have similar laws in different countries when you're managing your portfolio of investments, if you want to think about it that way. Last, colonialism was highly uncompetitive. We saw in the treaty with Opobo, the one article they crossed out was the one saying you can have free trade with other people from other countries. There was suppression of networks between African countries, particularly with different colonizing powers. There was inattention to laws facilitating local competition, and countries were essentially locked into exploitative relationships with the colonial powers through those networks. And this partially explains the appeal of doing business with China today, right? People see this as a way to potentially break some of the most negative aspects of these networks. And if we think about competition, it's amazing how clear they are in their discussions. So this is a British colonial official who says, it is probably true that the natives have not been encouraged to develop large handicraft industries for export, because such export would compete with similar industries in the United Kingdom. You always have to remember there is a reason for owning a colony. I will say this as much, that the hard-boiled principle of running a colony is to develop it only in the sense that you develop its production and export of raw materials. Don't allow any outside capital to be put into developing colonial industries, because in many cases they will compete too successfully with mother country industries. Every finished article must be imported into the colony from their mother country, with the exception of certain things. So this means that we've had the development of countries that are structured to be non-competitive. So as part of this formulation for thinking about the future, thinking about how do you sort of overcome this lack of competitiveness that was ingrained structurally is something to think about. So lastly, regulating new technologies, we have two issues. The global issue of mismatch between regulatory and legal mismatch for new technologies, and colonial legal overhangs are our two challenges looking forward to the future. If we think about not only new technologies, but more generally, but it becomes particularly highlighted in the case of new technologies. Lawrence Lessig basically says that cyberspace demands a new understanding of how regulation works. And I think what he's suggesting is we need to have new technologies require regulation that's flexible, with a good understanding of underlying technologies, and understanding of potential courses of development for new technologies. We have to think about potential futures. And we also have to have attention to the broader social, economic, and other consequences of new technologies. I would actually expand this and say, in general, when we think about lawmaking in African context, these are principles that can be a starting point for thinking about how do you regulate in an environment where in the past there hasn't been flexibility and there hasn't been the power and authority to really control your own destiny or visions of your own future. So I will end with saying that questions of legal reform in many African countries are complicated by pervasive colonial legal legacies, and they in some ways are problems of borrowing. And I would say that my thought, if we're thinking about how to examine, review, and modify borrowing practices, 4 or 5 questions to ask is, what is the source? Do we have hybridity? Authority, who chooses, who pays? What's the role of experts? What is the accountability of all these people? If we think about lawmaking and regulatory processes, do we have consultations with relevant people, local persons and organizations? Localization, I think, is a separate question to ask as well. It's embedded in some of these other questions. What kind of local connections and decision-making impact do we have? And I think, what kind of assessment do we have of outcomes? These are all questions I think we need to think about, especially in context of countries that are post-colonial, that haven't had power and authority over their own lawmaking processes in the past. So I'll end here. Thank you, and I look forward to your questions.